say there's only two things sure in life, death and taxes, no? So that's covering them topics here today. So I just wanted to introduce you to the two speakers that we have here today. First of all, Kathy Pilkington. Kathy has her own firm here in Madrid. She specialises in law, both Colombian and Spanish qualified. She's also qualified to practice law in Ireland. Okay, so she has a link with Ireland. Her husband is Irish. He's here today somewhere. Yeah. So she's very well positioned to advise us. She specialises in inheritance issues, wills, property purchases, residency permits, and also from her background in Colombia, investing in Colombia. No? So she's going to talk to us today about inheritance and wills. Okay. We also have Rocio and Lorenzo. Rocio is works for Quality Advice. That's basically a firm, tax firm that advises companies on tax issues and also individuals. They have their office in both Dublin and Madrid, so they have the link between the two countries. And she's going to talk to us generally about issues and obligations around both tax in Ireland and in Spain. So it's great to see a lot of people here. I don't know, is it so much interest or kind of a need to know that drives a lot of people to come here? Definitely in terms of in terms of the inheritance, it's always something that I need to do a will, but you never kind of get around to do it. So let Kathy explain to us why it's important to have a will. Thank you very much.
Thank you, Paul. Thank you all for coming tonight. Thank you all for coming tonight. I expect actually that this conference will be a way for you to organize your personal finance with a view to the future. So I'm going to as well to thank the Spanish Irish Business Network and then I don't know if Kathy Higgins is here as well for all the help to put this together. So the title of my conference is the impact of the EU succession regulations on Irish residents in Spain. So that's the first thing. I'm going to talk only on the impact on Irish residents in Spain. I'm not going to talk about Irish residents in Ireland with a second house in Spain or Spaniards in Ireland. Of course, it's going to affect them, but in another way. So I'm going to divide my conference in 4 topics. One, I'm going to make a comparative study about Irish and Spanish inheritance law. And then you are going to think why, if we are Irish, why we need to know about Spanish. And then is the second topic. We need to know because one or the other is going to be applicable to all of us. So I'm going to do some practical cases and my conclusions. So let's start with a comparative study about the law. Of course, I'm going to give you an overview. It will be very difficult only in 20 minutes to give you full or to go in depth. So I consider that there are 3 main differences between the Spanish and the Irish inheritance law. And then in Spain, for example, when a person dies, the heir is very important. The heir always has to accept the inheritance. Why? Because the heir is going to take the place of the deceased. He's going to take the good and the bad. For this reason, I don't know if you have heard that with the recession, a lot of people are renouncing to inheritances precisely because they get the bad. In Ireland, we don't have that. If a person dies, so the personal representative, the executor or the administrator is going to be appointed by the High Court, and then they are going to administer the estate. So they are going to pay the debts, they are going to distribute the assets, and if there is something left, it's going to be given to the heirs. So the second difference is what everybody knows, the freedom to the state in Ireland And then the second is the fourth archive in Spain. I'm going to explain this later. And finally, I think it's more formal. Here we make a will in front of the notary in Spain. In Ireland, in front of our solicitor. So the similarities in the two systems is that when a person dies, two things can happen. If the person doesn't have a will, we say that this person has died intestate. So in that case, if there is no will, or there was a will, but then the will was void because it was made under duress. So in that case, the law decides for the person. If the person dies, the state is because a will has been made. And then we're going to follow the instructions of the state. So is this clear? I'm going to start to explain what happens in both countries when there is no will. That I think is most of the cases, not only here but outside as well. So when we die in the state, the law decides for us. As we didn't give any instructions, so they take the decision, or the law actually presumes what actually we wanted to do. That law in Ireland is the Succession Act 1965, and in Spain is the Civil Code that actually I have here. The Civil Code applies to all Spain except for 6 parts: Baleares, Catalonia, Aragon, Galicia, País Vasco, and Navarra. So they have their own inheritance rules. So you have to be very careful, it depends where you live. If actually is none of those, applies the Civil Code and everything what I'm going to tell you today.
Can I just ask, sorry,
Yeah.
does the law apply for where you're a resident or where the property or whatever it is?
Depends.
Oh, okay.
I'm going to explain today. So, I'm explaining when you don't have a will, what happens. So the law decides for us, and in Ireland, if a person dies, survived by children, or no spouse or civil partner, the estate is going to be divided between the children equally. If actually the person was died, survived by a spouse, civil partner, and children, 2/3 goes to the spouse and 1/3 to the children. Yeah, it's clear. If there was only a spouse but no children, the spouse gets the entire estate. As I only have a small time, so actually I'm going to, if you want to get more information, actually you can meet me at the end of the conference. But then this is what I want to get clear, is that the law tries to get the next of kin, which will be, if you don't have children, spouse, so the next of kin are the parents. And if there are no parents, who do you think? The brothers and sisters. There are no brothers and sisters, the nieces and nephews. Then the other relatives, the next of kin, the nearest next of kin, and if there are no relatives at all, the estate, which happens. So in Spain, I'm going to highlight the main differences. And then the first one is that in Spain, the civil partner doesn't have any inheritance rights as Ireland. So if you have a partner, in the civil code, actually this person doesn't have any inheritance rights. And even for inheritance tax, is considered as a stranger. So the civil code says children and no spouse, so the same. So the children get the entire estate. And here we have the first difference. So children and spouse, we said here 2/3 for the spouse and 1/3 for the children. So in that case, the children get the entire estate and the spouse gets 1/3 as a life interest. Life interest is an interest on the property. It's not an absolute right of ownership. It's only the right to enjoy the property, so the person cannot sell the property without the consent of the children. So the other difference that is very important for people who are single or who are married but no children is that when we have the spouse, in Ireland the spouse gets the entire estate. When we have the spouse here, then the parents of the deceased are alive, the parents get the whole estate. Yeah? And the spouse only half of the estate as a life interest. Only the spouse gets the entire estate when there are no children and parents.
Have to get on well with the mother and the father.
Yeah, yeah, actually one of the cases that I have. And then it's the same rules. Tries to get for the next of kin, brothers and sisters, and nieces and nephews. The other relatives until the 4th grade of consanguinity, and if there is no relatives, the estate. So I repeat and I summarize that this is only when you don't make a will. This is what happens when you don't make a will. Or when you make a will and actually you make a very bad will, which is void or no valid. So the second case is when you die at the estate. This is when you have made a will. In that will, you have given instructions. What do you want to do with your asset? So in Ireland, we have freedom to the state. But then that freedom to the state is subject to the family provisions. The family provisions are rights that some people have over the assets. And this is the legal right chair, I don't know if you have heard about that, is the right that the spouse or the civil partner has over the half of the estate if they don't have children, or a third of the estate when they have children. So it's a right that the spouse has, or the civil partner. And then the children, they have the right, but then it's not an absolute right. They have to make an application in court, and this is when a child feels that the testator, who is the father or the mother, hasn't provided for him adequately or properly during his life. So the application will go to the court, and the court will decide if the parent has failed in the moral duty to provide for the kid according to the assets of the testator. In Spain, we have the famous forced heirship. So we don't have in Spain freedom to the state. We have to respect a part of the assets for some people. So those people are the children or the descendants, the parents or grandparents, and the spouse, but only a life interest. It's what we have to reserve for the spouse. They don't work like the rules of intestacy, or kind of, because if you don't have children, you have to reserve for your parents. But then the spouse can be in this part, as I'm going to explain. So we have a person who wants to make a will, and then this person has children but no spouse. So in that case, the person who wants to make the will has to reserve 2/3 for the children. Half will be divided equally, and then the other half is to improve any kid that he wants. It could be that he wants to improve only one kid, or at the end of the day he wants to improve all of them equally. And one third is free disposition. Now we're talking about a person who has children and a spouse. In that case, it's the same donor. It's 1/3 free disposition, 1/3 divided equally between the children. And remember, this is the third to improve the kids. So this one as well will be given to the spouse as a life interest, 1/3 of the estate. So here we're talking about a single person with no spouse. So a single person with no children has to reserve 50% for the parents. And 50% will be free to dispose. So we have a person who is married, doesn't have children, and has his parents alive, or her parents alive. So in that case, a little bit complicated. It's 1/3 for the parents. The spouse gets half as a life interest, and then the rest is free disposition. So we're talking about a person who is married and doesn't have children. And finally, a spouse who doesn't have children, or a person who has a spouse and doesn't have children, and as well his or her parents died, so has to reserve for the wife 2/3, but only as a life interest. So you see, the spouse never get, according to the law or to the forced heirship, anything in ownership, only in life interest. It will be different because remember we have parts of free disposition that we can give to the wife as well as in ownership.
So where does it?
It probably might be worth you explaining what you mean by life interest. I don't know, it
Life
means you
interest-
live in a house free, like,
Yeah,
you know,
so the
or
person
get
has the
rent.
right to live in the house, not to pay rent,
Yeah.
has the right to receive all the money, the interest for a deposit account.
Mhm.
But then, for example, in the example of the house, she cannot sell the house. Yeah, she can't.
So where do the assets go after that?
What do you mean? What the assets?
Yeah.
The life interest finishes.
The life interest finishes.
The life
This
yeah,
house
the
is
life
no
interest,
longer
that
alive.
lasts,
There is no children or there's no parents.
I don't know if it's your question. The life interest lasts the time of the spouse
The life.
is alive.
Exactly.
And as
Yeah.
well, it can happen that I'm only talking about the forced heirship. I'm not talking about distribution of the assets. That's another thing.
Okay.
Because in the
That's where-
distribution is when actually, if the person gets, or you see that here, in this case, for example. How? I don't know how
To go back.
sí, pero no funciona. Maybe you can click on the one you want.
Qualquer,
Which
sí.
one do you want? Mark?
She wants to go back.
Yeah, this one. How much? For example, this is a good case. I think is your answer. You see, the spouse gets 2/3 of life interest, but then the rest is free disposition. So if the spouse is the only heir at the moment of the distribution of the assets, if actually she got the whole thing because the husband left everything in her name, it merges. So actually she will have the ownership of the property. Is that the question?
Ah,
Yeah?
okay.
But then maybe this person leaves everything to a good friend, a charity. So she will have
Explicitly,
over the assets 2/3 as a life interest.
and then would be forced to leave it to the charity. It goes on, it's owned by the charity when the spouse dies.
Yeah,
That's-
because actually it finishes when the person who is benefit from that dies. Okay? So, everything to explain this, that with the new regulations, one or the other can apply to us. The new regulations is stated in 2012, but then actually only came into force on the 17th of August 2015. So it only applies for deaths after the 17th of August 2015. So if you have a case of someone who has died before, those rules don't apply to that. Another thing that is important to mention here is that it's a new instrument. It's even not 1 year. So this, at the moment, is something that is trying to start in the EU, so it's quite new. Important of the instrument is that unify the field rules in the EU. The field rules is the private international law rules about what law is applicable for the inheritance. Because each country has a different private international law to decide which one is the law applicable to the succession. I'm going to explain this later. The second part is allows a person to organize his succession according to the law of his or her nationality. So, in that case, if a person makes a choice of law, can organize all his succession and guarantee the rights of the legatees, the heirs, and even the creditors, because everybody knows which one is the law that is going to be applicable. I'm going to explain this in detail as well. And the last one that actually is not part of this conference, but then it's important to know, is the creation of a European Certificate of Succession, which is a document in which the heir or the executor is going to be recognized in the rest of the countries of the EU. So it's going to simplify matters. So I said that to unify the bill rules, this is what I mean. Actually, there are two systems. In some countries, for example, Ireland, the UK, and Germany, they use different laws to apply to an inheritance. For example, they use one law for the movable property, like an account, an investment. So they use the law where the person resides or is domiciled, and different laws where the properties are located. So one succession can have different laws. But then in the case of Spain or Germany, Germany is only one law. It's the law, for example, before the regulations came into force, for some people, for example, for some countries, it was the law of the nationality. For the reason we didn't have to worry about the Spanish law, because our law, our personal law, was with us even when we died, even if we were resident here. And now, the new regulations have decided to unify and only to use one single law for the whole inheritance. It doesn't matter where the heirs and the properties are located. So this will work, and then it will be fantastic because it applies to all EU and simplifies as well the conflicts, except for the fact that Ireland, UK, and Denmark are not part of the rules. Yeah, so they decided to opt out for the regulations. The reason why was because I need to go back. I don't know.
It's the arrow. Ah, vale. Clever boy.
So, they decided to opt it out because if you see, the regulation chose to have only one single law. So, who had to change everything? Ireland and the UK. So, all the common system had to be changed. So, even though they participated in the negotiation, they decided not to sign the regulations, which is a pity because it has frustrated the purpose of unifying all the inheritance rules. So we have a big problem because Ireland keeps using this, and the jurisdiction in Ireland, the courts only use this. They don't want to see, or they don't have anything to do with the new regulations. So in Ireland we have one law for the movable property, where the person actually is domiciled, and actually if the property is outside Ireland, they don't deal with that. They actually will be the law where the properties are located.
So basically, you have property in Ireland, the Irish rule apply.
Yeah.
To that property.
Yeah, if you are resident in Ireland.
Yeah.
Yeah.
No. If you're resident in Spain, but you have properties in Ireland, Irish law applies.
Yeah, and it's going to be a conflict of law. Depends what you do. It's one of the cases that So even though the EU rules don't apply in Ireland, UK, and Denmark, applies to Irish residents in Spain. Remember I said at the beginning that I'm only focusing on Irish residents. Why? Because when we die, the Spanish jurisdiction will have to decide what law is applicable, and then they are going to take the rules because this is what they signed for.
But the Spanish can we not decide that for ourselves?
As well, yeah. Yeah, but then it's more complicated, you know why? Because Ireland is not part of the regulation, so you can't choose an Irish jurisdiction because you can choose it, but then bring the papers to the High Court and tell them to apply Spanish law. They are going to tell you no, because my jurisdiction is only in Ireland. You can, but then you will find lots of trouble. Yeah. So the regulations brought new big factors, new private international law factors, and we have 3 factors. One excludes the other. If you are in the first one, excludes the second and the third. If you are not in the first one, goes to the second. So as you said, the law applicable to your succession will be the law that you choose. So but there is not any law. You can only choose the law of your nationality, because it's to give certainty that actually it's going to be only one law. And if you have multiple nationalities, for example in my case, Colombian and Irish, you can choose the one that you want. Of course, for me, if you have freedom to the state, it's better the Irish law. And as well, you have to make a will. That's the condition. You can't only say, I just want the Irish law. You need to make a will, and then not only to make a will, you need to make this really very clear that you want to have the choice of law. If you don't make it clear, it goes to the second forum. So the importance is that at the beginning we'll apply the choice of law, but then it will be the law of our nationality and in a will. If actually we don't make a choice of law, so the rules apply the general rule. So by default, the applicable law will be the law of habitual residence at the time of death. So if we are at the time of our death, we are in Spain, so we'll be Spain. If we move to have our habitual residence in Italy, we die in 20 years, we will be the Italian law, not the Spanish law. It's when we die, the place where we die. So if the Spanish law is applicable, it's everything. What I displayed to you about forced-ship, inheritance rules, is the way to avoid, or maybe you don't want to avoid. Each person is a case, it's a word. So, but then if you don't want to have this, so you make a choice of law, and then you choose the national law. There is one exception, something very important. What is a habitual residence? This is what we want to know as well, because the rules doesn't say anything. The rules don't say anything about the definition of habitual residence. It's a new instrument, as I said to you, because it's only August that came into force. So there are no precedents from the Court of Justice, the EU, defining what is habitual residence. But actually what we're doing at this moment is using what the other instruments of the EU have defined as a habitual residence. And habitual residence is where you have the center of your business, of your interest. So your business, your family, your friends, your social life. So where is the center of your interests? Of course it changes. There are many cases, people who have different habitual residence because they work or maybe they have different habitual residences. So each case will have to be checked independently. And then this section, that is only an exception, is when the laws, the law of the country, of the habitual residence won't apply if you can prove that actually you have the strongest connection to another country. Why? Because you have been a person who works in Belgium only from Monday to Friday, and the life of the center of your life or interest is in Spain, where you have your family, your friends, you read the newspaper, the Spanish newspaper. So that's the section. So unfortunately, the regulations don't apply to many things. I try to summarize some, but then this is a very important thing, taxation. So it didn't say anything, which is quite complicated. And actually what the recitals say is that each country will apply the same law, their own laws for taxation. So it's, I think, your question depends where the asset is. So it will apply, yeah. The taxation
So
is
you apply the
different.
inheritance rules in
different
Ireland
to-
if you have property in Ireland, no?
That's different. This is the law applicable. I'm not talking about taxation.
Okay.
Taxation can be different. And there will be another conference about how is the taxation, because it's
Oh, yeah.
different. In Spain, it's quite complicated. If you are resident, receiving things from non-resident, or a resident applies to this.
Tell me about
So I hope I can get through, and then maybe that's the way to know if actually I did. So I have this case of an Irish citizen. Actually, I forgot to put here that is resident in Spain. This person is married, 3 children, 2 houses in Ireland, no will, so no choice of law was made. So what law do you think is the applicable law? He didn't make a choice of law.
Spain. Spain.
Habitual
It's the
residence.
Spanish law. So, and then do you remember if a person dies without a will made, what is the rules of intestacy in Spain?
One-third to spouse, 2/3 to children.
Yeah. Your case. Okay, did you see that actually the person has properties in Ireland? So we're actually the Spanish law is going to be applicable, and then, so we're going to transfer the properties in Ireland in the name of the heirs. So we bring our papers to the High Court in Ireland, and then remember that they don't apply the rules. They don't want to do anything with this. The houses are in Ireland. So actually, if you haven't made a choice of law, you are actually creating a conflict of laws, because of course when the Irish jurisdiction is going to deal with the properties, but then you will have 2 different laws, and then it's not acceptable by the regulations. So maybe you will have problems doing that. And so the best in that case is maybe to make a choice of law. When you make a choice of law, to give everything to the spouse, and then, I don't know if you know that in Ireland, the spouse doesn't pay. If you give everything to the spouse, there is no inheritance tax, for example, will be the case. So anyway, the Irish law will be applicable. So when it goes to the Irish court, even though they don't accept the rules, at least they are going to apply Irish law. So it will be the same law, and then it will simplify matters for the heirs who are going to have those problems. The second case is an Irish citizen, resident in Madrid. He's married, and then he doesn't have children. Has assets in Spain and Ireland. No will and no choice of law made. In that case, will be Spanish law, because he didn't make a choice of law. But look what is going to happen. What the rule? Do you remember the rules of intestacy for a person who is married and no children?
To the parents.
To the parents. So here you are creating a conflict of law, the same one, and a conflict in the family. Because who knows if the parents-in-law get on very well with the daughter-in-law or the son-in-law, who is in another country as well. So if you make a choice of law, it will be easy as well for this person to give everything to the spouse, the same.
Can the mother-in-law, father-in-law renounce and give it back to you? Or they can't,
Yeah,
right?
they can. So but then, if they get on, I suppose. If they get on, yeah. You know. Yeah, maybe everything works well because it's a very good family, and then so they understand that actually the house belongs to her, but not always is the case. Otherwise, we won't be here. If everything will be easier. Sometimes, yeah.
Excuse me, if the spouse that if their parents are deceased, what happens now?
Yeah. In that case, if the parents are deceased, remember the spouse gets everything. Remember the rules of intestacy. If so one thing, if the grandparents are alive, yeah. But then I think if the parents have died, so actually the spouse gets the entire estate. Yeah, but then we will have a conflict of law because he has properties in Ireland. So and then it will be complicated to get everybody together. So we could have made everything easier beforehand, and organize everything before all these problems stand. But maybe we don't know in 10 years how the relationship is going to be. And the last case is very important for people who have made wills. Here, if you have made a will, this is your case. So we have an Irish resident in Spain, and this person made a will in 2005. So remember, in 2005,
Sorry, is that a will made in Ireland or a will
in
made
Spain.
in Spain?
He's resident in Spain, and then this is important. Yeah, important question is when he made a will in Spain. So Irish resident in Spain made a will in Spain in 2005. At that time, our personal law was the Irish law. So actually, it didn't mind what you put in the will was always going to be the Irish law, the law applicable to our succession. So he made a will, he divorced and married for a second time and had children from the first marriage. So he leaves a will and he leaves everything to his second wife.
Okay.
So, no, but then they are the cases that you always see in the Supreme Court, because here is the problem. There are some children that they have a forced heirship here in Spain, and then he's not giving anything to the children. He's giving everything to the second wife for any reason to do that. So the question is, what do you think? Can the children contest the will and ask the judge to apply forced heirship?
Yes.
Someone maybe who thinks no?
Well, if they made Irish law apply, once you able to get
Exactly.
Irish law to apply.
What's the point? Depends. Even yes or no is the answer, because depends. If he made very clear in that will how, for example, he made a will in two columns, one in Spanish and one in English. He maybe said that he was Irish. He mentioned that he could have done this because in Ireland there is a freedom to the state and then to give to the wife. In that case, the children will have very difficult to contest that will. But then, if actually he made a will, at that time the rules didn't apply, and he made a will in Spanish, because it's possible for us to make a, if you are fluent in Spanish, the notary is going to make a will if actually he feels that you understand everything what you are signing. If you made a will in Spanish and you didn't even mention nationality or anything, so it will be, we will have a case for the children to try to contest and actually they win. So the law, the Spanish law will be applicable and the reserves will be put in place. Yeah, is that clear?
Mm-hmm.
So depends. It's very important, the choice of law. So if you have made a will previously, it's necessary for you to update your will or to see that actually you have made a choice of law, a reference to the Irish law as clear as possible. Otherwise, in the case that your will is contested, and not everybody is going to contest the wills as well. It depends if you, actually in this case, you are not mentioning the children, but every case is different. So my conclusions. As you know, it's very important to make a will and to choose, yeah, and to make a will, and then to update your will and to choose as well the law of your nationality. As well, I think it is like a second conclusion is that if this instrument is giving the right to organize our things, why not to take advantage of that and to organize in this moment, like a point of personal finance for us to organize this in the future to try to avoid taxes or legal cost. And this is more the conclusion that it's not only, I don't want you to live today thinking that, choosing the law. No, actually estate planning is even more. If you have children, it's very important to appoint guardians, that you know people that if you have an accident simultaneously with your spouse, who is going to look after the kids and as well how, the money, who's going to manage the money for the kids. As well, if you become unable to take decisions, what your instructions are about yourself, and not to leave those decisions to the other person. And as I said, to minimize taxes, cost, and unnecessary legal fees. Each case is different, and as well as I said, as Ireland is not applying the rules, So it depends where your assets are located, what assets you have, where your heirs are, and where did you get married? In Ireland or here in Spain? That's important because in Ireland, maybe we have all our properties like joint tenants, and then here is different. Here, if we don't say anything, we are in gananciales. Remember this? So we share everything together. So when I say that we have to reserve part, for example, if we have a house, that house, if we are in Spain and they will have gananciales, is not the whole house. It's only 50% of our estate. So depends as well of that. In joint names of the gifts can be given in Spain. That's very important as well because as well if you can, in Spain, if you have given or the testator has given gifts during the life, those gifts maybe can be brought to the state and to be accountable again. In Ireland, no. Actually, once the gift is given, is not brought back to the state. So, thank you very much, and I hope that you have clarified